history. None of us can. Right or wrong, good or bad, we can't undo the past. It became fairly apparent over the course of this proceeding, at least to this court, that really the only significant factual dispute between these parties in this case was whether or not Mr. Eldridge's conduct constituted self-defense. That was the issue to be tried. There really wasn't much in the way of factual dispute that I could see. And having heard from counsel now today, it appears that they effectively agree with that assessment. This court hasn't and wouldn't see all of the evidence held by the parties, but this much is clear from that. What is proposed before this court today is absolutely a compromise that this court believes serves appropriate goals that are laid out by each. The state has valued a felony conviction here, and what comes with it, a permanent future prohibition from Mr. Eldridge possessing a firearm. The defense has prioritized or valued release from custody so that he can seek treatment for his injury and to limit his exposure if he were to be convicted of the underlying counts. That's not particularly unusual. I thought it was significant, and maybe I was the only one that noticed it because of my perspective on the room, but Attorney Chambliss has been very clear, unfailingly clear, about his assessment of this case from the first moment that he was involved in it. The first time I presided over anything related to this case, and Attorney Chambliss made it very clear what his position was, that he believed that his client had acted in self-defense. And so the statement that he made today in support of this agreement was not particularly surprising to me in that comment. But I could easily see where others who maybe hadn't been involved in this as frequently might wonder why, at the close of his comment, there was an afterthought. This expression of remorse for the loss of Mr. Reynolds' life. And I want to be clear that I don't think that was an afterthought by Mr. Chambliss. Mr. Eldridge prompted that. That was my perception of what occurred. And again, that might have been difficult for others to have perceived, but that was my perception, was that it was Mr. Eldridge that prompted that, to make sure that that was part of the record today, to make sure that Mr. Reynolds' family heard that. That's important to this court because I think it's a sign not just of Mr. Eldridge's remorse for what has occurred, but a sign that he understands the magnitude of what has occurred. I am concerned, frankly, about what has been proposed here today, what an outcome like this might send as a message to the general public. Largely, frankly, because there hasn't been a full and public vetting of all of the evidence in the form of a jury trial. That's what we would have been doing otherwise today, as we've already talked about. However, given the facts as they have been alleged in this case, as I understand them, including the history between Mr. Reynolds and Mr. Eldridge, I do believe that at least the framework of what has been agreed upon is appropriate under these circumstances. So, specifically what that means is as it relates to count 3, and I'm going to kind of do this in reverse order on purpose. On count 3, I am going to sentence the defendant to serve 180 days in the county jail with his 135 days of sentence credit. That's time served, and I will require that he pay court costs associated with that in the amount of $243. On count 2, I am going to withhold sentence and require that the defendant serve 4 years of probation. Conditions of that probation, however, will include court costs, the amount of $568, a DNA sample, anger management counseling, and I am also going to impose 9 months in the county jail. I am going to stay that, however, at least in the interim, to permit the defendant to receive the medical treatment that he has repeatedly argued that he needs to address that issue. But I am going to require that jail term be served in the first half of the period of probation. So it's got to be done less than 2 years, within 2 years from today's date. That should give the defendant an opportunity to receive the appropriate medical treatment that he has indicated that he needs. But also, I think, is an appropriate response under these circumstances. Ms. Long, we still have the issue of restitution to address. Are there any other issues that we need to address beyond that?
No, Your Honor.
Mr. Chambliss, other than the issue of restitution, are there things that we need to address?
Will that 9 months be with Huber privileges, Your Honor?
Yes, sir.
Not at this time, Your Honor.
All right. Then, as to the issue of restitution, I guess I'm still a little in the dark about where we're going with it, so who wants to go first?
Well, Your Honor, I could provide the court, at least with the documentation for the funeral expenses. Other than that, which is not actually in dispute, I don't have other information to provide to the court, as I believe the argument's going to be more in regards to the defendant's ability to pay.
Well, it will be that, Your Honor. I guess I'll just give my argument. First of all, Mr. Eldridge's only source of income is his wife. He's unable to work. He's got significant physical disabilities. He's got 5 bulging discs in his back. He's had both of his knees replaced. He's seeking Social Security disability. He would need Huber privileges just to provide child care because they've got a special needs child at home, and right now they've got nobody to help care for her. Mrs. Eldridge works about 40 hours a week. She makes $12.50 an hour, and out of that she supports the 4 of them. So then on top of that, I'd ask the court to consider this. I don't really think it's disputed that my client was a victim in this case as well. He was attacked by Victor Reynolds. Victor Reynolds came down the stairs and attacked my client as my client was leaving this apartment building. So I don't think that he should be required to pay the entire costs of this. And the factors that the court can take into consideration, I mean, the law requires that you order restitution, but in terms of the amount of restitution, it's within the court's discretion, and you should consider the defendant's ability to pay and other factors. And I'm asking the court to take into consideration the equitable factors here. My client suffered great bodily harm in the course of this assault. My client was attacked by Victor Reynolds. It wasn't the other way around. And he simply has no means to pay $7,615. So if the court orders him to pay, I request the court order him to pay some portion of that, but not the entire amount. Thank you. And then, of course, he'd need plenty of time to pay it because he has no income.
Ms. Long, the state's comments, if any, about that?
Your Honor, it doesn't seem like a unusual amount of expense for a funeral. In fact, it looked reasonably low to me. I think that the defendant's actions caused the death, and that's all we're looking at, really. Caused the death of Victor Reynolds. But for those actions, Victor Reynolds' family wouldn't have had to pay $7,615.13 to bury Victor Reynolds. The least that the defendant can do is cover the expense of that. I mean, they can't bring him back, obviously, but he could pay for the funeral.
Mr. Jimbo, I'm sorry, did you have anything else that you wanted to say?
No, Your Honor.
Okay, I didn't want to interrupt, and I wasn't
No,
sure.
sir, I was just going over the post-conviction rights form with my client.
Fair enough. As it relates to the issue of restitution, I think, frankly, the court is, Mr. Jimbo is right. I have to consider the defendant's ability to pay in all of this as well. It's not quite as simple as the calculus that Calvin Eldridge's behavior caused the death of Victor Reynolds. If that was true, if that was the only consideration for the court, this would be a very simple discussion, and we probably wouldn't have even had to talk about it. There would have been an agreement to do that, to pay the full amount as a result, or as a condition, pardon me, of the restitution, or the condition of the probation. And the fact that the defendant doesn't otherwise independently have his own income at present is certainly a factor that this court is statutorily required to consider. It should not, in this court's opinion, however, absolve him of responsibility for the financial consequences of his choices. I am going to require that the defendant reimburse Darlene Kosbowski. I hope I pronounced that even close to correctly. It appears that that's who paid the bill. That's anyway that what I have here, or whomever actually paid the bill, just to be clear about that. If that's not who paid the bill. $4,800. That amounts to $100 a month during the period, a 4-year period of probation, I expect that it will be paid as a condition of the probation. Frankly, based on what I've heard here today, I expect the defendant is going to struggle some to pay that. But I think that it's appropriate under the circumstances that he pay up a substantial portion of it. And I think that I would expect regular payments to be made during the period of probation related to that amount. Ms. Long, other issues for today?
No, Your Honor.
Mr. Chambliss,
No, Your Honor.
you do have that post-conviction rights form for me?
I do.
Be in recess for today.